Very good morning, my dear friends. In today's session, we will deal with the further issues under the bank guarantees. Earlier, I have covered the definition of bank guarantee and the law applicable, that is basically 8 sections 126 to 147 of the Indian Contract Act as they apply, and then the various other issues also I told you. And basically, I told you that there are three parties in bank guarantees, that is the surety, the principal debtor, and the creditor, of course. The different types of bank guarantees also I told you. In that event, whether it is a specific guarantee or a continuing guarantee, that we are going to see subsequently. In fact, apart from these sections 31 to 36 of the Indian Contract Act relating to contingent contracts also will apply to bank guarantees. In fact, in furtherance of our discussion, we had to deal with this subject also. Then, friends, apart from all these provisions, sections 126 to 147, and then 31 to 36 pertaining to contingent contracts, the regulations, guidelines issued by Reserve Bank of India from time to time relating to sanction and invocation of bank guarantees also must be perused. They must also be applied with regard to sanctioning, invocation, and revocation of bank guarantees. Then, friends, in brief, we will deal with the features of bank guarantee now. The first one, the first feature of bank guarantee is that there should be in existence a recoverable principal debt. So, the contract of guarantee basically is dependent upon the fact that there is a recoverable debt. Suppose the debt is not recoverable, question of guarantee does not arise. So, the famous case of Swan versus Bank of England, Swan versus Bank of Scotland. I apologize. Swan versus Bank of Scotland, 1836. The House of Lords decided this matter, where in this case the payment of overdrafts of a banker's customer was guaranteed by the Bank of Scotland. And friends, it was later found that the overdrafts were contrary to a statute. So it was held that the bank was not liable, and the House of Lords observed that if there is nothing due, no balance, the obligation to make that nothing good amounts itself to nothing. If there is nothing due, no balance, the obligation to make that nothing good amounts itself to nothing. That means there was no principal recoverable debt. However, an exception to this rule was laid by the Chancery Division in 1925 in Garrad, Garrad, Garrad versus James, where the Chancery Division held that a guarantee, even for a void debt, was enforceable against the directors of a company. The circumstances are different here. If they guaranteed their company's loan in their individual capacity, which was found to be void as being ultra vires. So here the circumstances are different because the company's interest has to be protected always. Then, friends, the second feature of a bank guarantee is it's a tripartite agreement as provided under section 126 of the Indian Contract Act. The third point is it must have consideration as provided under section 127, where it is stated that whatever is done for the benefit of the principal debtor itself formulates the consideration in a contract of guarantee. Then, friends, an important question comes as a fourth feature, whether contract of guarantee happens to be a contract of uberma fide, that is, it requires the full disclosure of all material facts, and it's a contract of good faith. So, in this particular case, insurance is different. Insurance contracts requires disclosure of all facts, but here it's not the case. However, under section 142 and 143 of the Indian Contract Act, there are certain exceptions to the rule that a contract of guarantee obtained by misrepresentation and or concealment is invalid. So since there are specific provisions, under those provisions, if these provisions are applicable to the circumstances of the case, then that contract of guarantee could be invalid but not as oberma fide. So, contract of guarantee are not contracts of oberma fide subject to the exceptions. The provisions laid under 142 and 143, the sections 142 and 143 of the Indian Contract Act. Then what is the modus of bank guarantees? The bank guarantee should be in written form only, and then necessary stamp duty also must be paid as per the Indian Stamp Act, and then read with the appropriate notifications of the appropriate central government or the state government, as the case may be. Then, friends, the next important aspect is the extent of liability of the surety. Under section 128, the liability of the surety is coextensive with the liability of the principal debtor unless it is otherwise provided under the contract. It is under section 128. In case of bank guarantees, the amount is fixed in the guarantee bond and the bank is liable to pay the stipulated sum on the invocation of the bank guarantee. So the principle as such directly would not be applicable. Then, friends, application of the essential requisites of a contract are concerned. All the essentials of valid contract under section 10 as enunciated under the Indian Contract Act are invariably applicable to this particular bank guarantees also. Then, friends, with regard to the kinds of bank guarantees, bank guarantee, basically contract of guarantee can be specific and continuing. A specific guarantee is one which is applicable for a particular transaction. A continuing guarantee is one which extends to series of transactions as provided under section 129 of the Indian Contract Act. In this particular case of bank guarantees, the bank guarantees are mostly issued on specific guarantees only. Very rarely continuing guarantee comes into picture. Then, friends, with this we conclude our discussion on the features of bank guarantee. Examination question comes. These are all the issues which we can raise and then give elaboration, and then the case law which I have given to you can be supplemented with further study of appropriate case law thereon. Now, friends, the next important issue is revocation, whether a bank guarantee can be revoked. In fact, a specific guarantee cannot be revoked under any circumstances, but it can be intercepted under certain circumstances so that the guarantor is discharged from the liability. That is where the issue comes as to discharge of a guarantor from his liability under varied circumstances. In case of fraud or misrepresentation and concealment of information, as provided under sections 142 and 143 of the Indian Contract Act, the contract of guarantee becomes invalid and the banker can refuse payment on the invocation of the bank guarantee. This is the most important aspect, sections 142 and 143 of the Indian Contract Act. However, under section 139, a continuing guarantee may at any time be revoked by the surety so as to future transactions by notice to the creditor. So, the bank can invoke this section 139 for revoking a continuing bank guarantee as to future transactions, but existing transactions already took place. In fact, that the question of revocation does not arise. But specific guarantee 142 and 143 of the Indian Contract Act sections speak that a concealment and then there is any kind of, in fact, misrepresentation, then the banker has got every right to refuse payment and the bank guarantees can be, in fact, withheld from being invoked. With this particular background, we will now come to another important subject, that there is a saying, there is a legal principle that a surety is also termed as a favored debtor. In the event how far this particular subject is covered with regard to the bank guarantees, because once a contract of guarantee is signed, the surety cannot go back. A contract of specific guarantee cannot be revoked on the whims and fancies of the surety, but continuing guarantee can be revoked only with regard to the future transactions. In that event, there are certain special circumstances under which a surety can be discharged from the liability. Though the contract of guarantee in principle cannot be rescinded, it can be intercepted. This is what I have been telling. And the surety can seek himself to be discharged, even a banker that way, from the liability, so that no more the banker can be termed as a favored debtor. Friends, the circumstances under which the surety can be discharged can be stated under different heads. The first point is by the surety in case of continuing guarantee, as I told you, section 130 with regard to future transactions. By the death of surety. Under section 131 of Indian Contract Act, the death of the surety operates in the absence of any contract to the contrary as a revocation of continuing guarantee. So far as regards future transactions, however, with regard to banks, that does not arise. But insolvency can come in, liquidation can come into picture. Sorry. Then, next important thing is by novation. Under section 62 of the Indian Contract Act, by novation, where substitution of a new contract for the existing one is made out, the surety is discharged from the liability under the existing contract. The fourth point is by variance in the terms of the contract. If the terms of the contract are varied by without notice by the parties, then to the surety under section 133 of the Indian Contract Act, surety is discharged from the liability. If the contractual terms are varied by the creditor and the principal debtor without the consent of the surety varied them, then the release or discharge of the principal debtor. Under section 134 of the Indian Contract Act, if the creditor releases or discharges the principal debtor, then it will eventually release the guarantor also from the liability. Then friends, under section 135 of the Indian Contract Act, if the principal debtor compounds with the creditor without the consent of the surety, then the surety is discharged. Then creditor's acts and omission under section 139 of the Indian Contract Act, impairing the surety's eventual remedy also would discharge the surety from the liability. Here the famous case is the Supreme Court's judgment in Amrit Lal Govardhan Lal. Amrit Lal Govardhan Lal versus State Bank of Travancore. Reported in AIR 1968, Supreme Court 143. AIR 1968, Supreme Court, page 143. Then the next important case, the State of Madhya Pradesh, MP versus Kaluram. State of MP versus Kaluram. Reported in All India Reporter, 1967. SC, Supreme Court, 1105. This aspect that section 139 of the Indian Contract Act discharging the surety from the liability due to the acts and omissions, impairing surety's eventual remedy. This has been very well analyzed. That could be taken into account in the same way the loss of securities also. The next important aspect is the loss of securities, where any loss of security occurred due to the negligence or act or omission on the part of the creditor releases the surety from liability either in full or in part, but limited to the securities existing at the time of formation of the contract. Then friends, section 140 to 143 with regard to misrepresentation and concealment of material in circumstances wherein the in contract is invalid, surety is also discharged. So friends, these are all the important aspects which we will have to take into account. And then the next important aspect is the rights of the bank guarantors. That means the rights of the bank which is under bank guarantee. Here the same rights of surety as provided in Indian Contract Act apply alike. As for example, the bank is entitled for exercising the right of subrogation under section 140, right to take over all the securities under section 141, and refuse payment under the context of invalidation of the contract under sections 142 and 143, and the right to indemnify under section 145 of the Indian Contract Act. Lastly, friends, there are certain important decisions of the higher courts which I want to bring to your notice because basically the bank guarantees are invocable without any demur on the part of the bankers. However, there are circumstances which were approved by the higher courts to restrain invocation, where there is fraud, misrepresentation, concealment of information, forgery, and like issues. The courts can interfere and restrain the invocation of bank guarantees. The Supreme Court and various high courts in this regard laid certain judicial precedents by the doctrine of stare decisis. There are few decisions I would like to bring to your notice. The one is number one, Maharashtra State Electricity Board versus Official Liquidator Ernakulam. Maharashtra State Electricity Board versus Official Liquidator Ernakulam, reported in 1982, Volume 3, SCC, Supreme Court Cases, page 358. In this case, the Supreme Court held that the courts must exercise caution in restraining the invocation of bank guarantees, as the credibility, respectability, reliability of the assured mode of payment through bank is necessary for the growth and promotion of trade, and the faith of people in bank should not be affected. The second one, Uttar Pradesh Cooperative Federation Limited versus Singh Consultants and Engineers Private Limited. Uttar Pradesh Cooperative Federation Limited versus Singh Consultants and Engineers Private Limited. Reported in 1988, AIR 2239, page number. The Supreme Court here observed the commitments of banks must be honored free from interference by the courts, and only in case of fraud or any case where irretrievable injustice would be done, if the bank guarantee is allowed to be encashed, the court should interfere. Because bank involves public money, and definitely the banker's interest has to be protected in case of fraud, misfeasance, forgery, and like things. Then the third one, friends, ITC Limited versus Debt Recovery Appellate Tribunal, reported in 1998, Volume 2, SCC, page 70. The Supreme Court held that the bank can refuse payment in case of clear fraud and the bank's knowledge as to such fraud, wherein the banker's interest is absolutely protected because it involves public money. Then Hindustan Construction Company Limited versus State of Bihar and others, reported in 1999, Volume 8, SCC 436. Hindustan Construction Company Limited versus State of Bihar and others, reported in 1999, Volume 8, SCC 436. The Supreme Court held that a bank guarantee is an independent and distinct contract between the bank and the beneficiary, and both the parties would be bound by the terms thereof. And as such, the invocation will have to be in accordance with the terms of the bank guarantee only, or else the invocation itself would be bad, and the bank under such circumstances were under no obligation to make the payment. Any deviation can entitle the banker to refuse the invocation. This is the most important provision, my dear friend. This is the most important stare decision, that is the case law, as enunciated by the Honorable Supreme Court of India. Then the next important thing, the National Highway Authority of India versus Messrs. Ganga Enterprises and another. This was reported in All India Reporter, AIR 2003, SC 3823. The Supreme Court in this case held that a contract of guarantee is a complete and separate contract by itself, and the courts must not interfere with its enforcement unless the enforcement is against the terms of the guarantee or if there is any fraud. Most important aspect. Then Viniti Electronics Private Limited versus HCL Infosystems Limited, reported in 2008, Volume 1, SCC 544. The Supreme Court held that the invocation of a bank guarantee can be stalled by the courts in case of fraud. So, friends, in the event of any fraud detected or any unlawful invocation of bank guarantee, in fact, courts can interfere and then grant an injunction. In that event, how the injunction has to be given is narrated, of course, under the CPC. But what is most important here is that the invocation is to be stalled. The courts will be cautious and conscious of the fact that, on one hand, it is the public money that should not go into drain. On the other hand, the faith reposed in banks through the bank guarantees should not be tarnished. So the courts have to draw a balance, bring a balance between these two situations, circumstances, and then ultimately they have to come to a conclusion as to whether such a particular relief can be granted or not. So, with this background, friends, definitely you can expect a 25 marks question, and then you can prepare well with my earlier, in fact, lesson I have taken up on the introduction, and then now this one. With this background, we conclude our discussion on bank guarantee, and in my next lecture, I will take you through the letters of credit. So, friends, we'll be meeting soon again. Thank you very much. Goodbye. Have a nice day. Thank you.